to the House. Kia ora.
Mr Chair, Mr
The
Speaker.
Honourable Nanaia Mahuta.
Tēnei katoa ki te tautoko a ngā mihi ki a koe e noki tūwhera te ara whata ki te runga rawa kia tau iho mai ona manaakitanga kei rungi a tātou mō tēnei o ngā huatanga ana ngā take tiriti. Kia tātou katoa tēnā tātou, Ngāti Pūkenga. Tēnei ka tāpiri atu e te heo oku nei whakaro, aha kua he iti. Ka tāpiri atu ka tuitui ki ngā kōrero kua whāriki hia I mui te aroro o tēnei paremata. Mr Speaker, I don't intend to take too long a speech in the second reading except to acknowledge the efforts of Ngāti Pūkenga to bring their claim through this process and to its finality. The reason why I'm not going to take a long claim is because the bill and the settlement passes on two fronts which are very difficult fronts and hurdles to get over. Firstly, in terms of overlapping claims, we heard previously in the former bill my colleague Penny Henare talking about the challenge of overlapping claims and the way in which Crown policy is applied, but the way in which iwi would prefer to exercise their relationships by whakapapa in connection to whenua and important places within their rohe. Ngāti Pūkenga passes this hurdle to the extent that it's evident in the way that the the cultural redress mechanisms have been achieved. They've been talking to their neighbours and they've recognised that in order to extend their own association and connection to a place, it's probably a good idea to recognise those of others within the rohe as well, and you can see that through the joint arrangements. We also didn't hear at the Select Committee any opposition to the remedies, the redress remedies that were being sought by Ngāti Pūkenga. Again, a good sign that a lot of conversations had taken place. Now, you know, that's a challenging space to navigate, but if one were to come into this process and consider the amount of effort that's required to get to Select Committee with relatively very few criticisms, I'd say a lot of work has been done behind the scenes. So, ka nui te mihi atu rā kia koutou Ngāti Pūkenga. On the issue of commercial redress, Ngāti Pūkenga have it's demonstrated, and it was evident at the Select Committee, that they demonstrated quite a strategic approach to their commercial redress, what was available and in fact what they might derive value from, and they've been very smart. But here's a lesson to all of us. It's not how big or small your settlement is, it's how purposeful you design the intent of the settlement for the benefit of your people. And one of the things that impressed upon me when Ngāti Pūkenga came to the table, and we asked them a few tricky questions. Obviously, we couldn't get away from the Hauraki issue, so as the representative for Hauraki, I had to ask that question. Was Hauraki reaching all the way down into Tauranga Moana through Ngāti Pūkenga? They were very diplomatic and took a non-partisan view on that. But beyond that, the questions were really around what did they intend to see as a benefit and opportunity for their people as a result of their settlement. Had nothing to do with size or scale, had everything to do with reconnecting their history back to the places where they expressed an association, had everything to do with ensuring that those, I guess, obligations of the Crown in terms of Ngāti Pūkenga specifically were recognised as having been breached, and had everything to do with the commercial opportunities that they saw could be gained from their settlement. So I want to commend them on that part. On the issue of Clause 103, we did spend some time on it. It was of interest that Ngāti Pūkenga, certainly for the treaty settlements that I've sat on, was the only iwi who had so clearly brought up this issue in a way that challenged us to really think about it. And if we really come back to the point that the chair of the Select Committee made around the committee considering that a review was necessary, the review would be interesting to be able to, I guess, get a context for how this particular clause applies, but also within the first right of refusal space, how effective that whole process was operating, whether the time notification elements were, efficient or optimised a transfer. Also the innovation that's been created within iwi to have internal rights of refusal and to be able to kind of trigger an improved process to build the capability of the iwi, so it's an and approach. So I think a review, in my mind, would be a way to signal to those who are currently have settled and those who are yet to settle that it's always an opportunity to improve, innovate and build on some of these mechanisms which are ultimately designed to support the aspirations of iwi in their settlement process. But on clause 103, who might the charitable purpose be? And I think we could only go back to the history of tauranga moana and the way in which lands were gifted, post-raupatu and things like that to say, actually, by and large, we may be talking about churches. One of the challenging conversations in the space of churches taking on lands either gifted or by other means transferred to them is how hard it is to get those lands transferred back to iwi. So there seemed to be an underlining element to the representation that was brought to us. And I am aware, I think, if I recall, in the Ngāti Ranginui or Ngaitarangi settlement, there was a specific piece of church land that was desired in the settlement. But it struck me as we're probably talking about a limited pool of charitable purposes which this clause might apply to, and it would harm no one to see whether or not, and I've heard what the Minister said, this is very rarely triggered, but whether or not it has been triggered and under what circumstances, just to get a more accurate feel for how real or not this particular issue is. Of course, we take the word of the Minister, and the Select Committee was in that situation, which is why no recommendation was made, but we did it based on the word of the Minister and the advice of the officials rather than really combing through from the time that this clause was inserted in the first right provisions to now. Has it ever been triggered? What were the circumstances? Did it create a prejudice against the iwi whose settlement the clause might have applied to? So things like that. As I said, I wasn't going to take a long talk. I want to make the final point that Ngāti Pūkenga interests within the Manaia area in the Hauraki part of the in the Hauraki rohe are yet to be resolved. Perhaps with the willful insight of the Ngāti Pūkenga experience and the way that they dealt with their overlapping interests, the whanaunga up in Manaia might use that and draw on that as some opportunity to try and get through the current state that they're in so that they can also get ahead. It's not how big or small your settlement is, it's the intent of the purpose and vision that you have for your iwi to benefit your people in the next generation, and I think Ngāti Pūkenga has achieved that well. Tēnā koutou.
Speaker. Dr. Shane Ricky.
Thank you, Mr. Speaker. Tēnā koe.